Okay, welcome everyone to this session, the first one in the morning on legal pluralism and computational antitrust for the digital transition. And we have three very interesting presentations lined up, so I really look forward to the discussion. And not to take up too much time and leave as much possibility for discussion, I will immediately move to the first speaker of today, and that is Oles Andriychuk, who is a professor at Newcastle University, who is joining us online and who will speak about legal pluralism and digital competition law. So Oles,
thank you very much. Thank you very much for the introduction and for the opportunity to present my research at this fantastic event. So my paper addresses the issue of legal pluralism. I'm trying to share the screen, but it looks that I'm disabled. So I'm okay without this because I don't have any diagrams or anything of this kind. So it's mainly kind of theoretical paper, and it starts from an observation.
Oles, if you like, you can try again. It should be working now. Yeah.
So it starts from the observation that we deal in competition law with hard cases, particularly when we talk about competition law and competition law in digital markets, competition law and sustainability, or any other. So it's like when we don't look at competition law sensu stricto in insulation from and rely on economic kind of metrics established apparatus, but it's kind of more a clash between different systems of norms or different systems of values or different legal systems indeed. So we don't look at self-executing cases, which are 99.9% of all cases. They are trivial. When those cases which are hard cases are somehow those which can be problematized, either because the stakes are very high, or because the parties are very skillful, or usually this is pretty much or maybe because the system itself is being drafted in a not very refined way, which allows a broader room for interpretation, which is not a pathological approach situation for legal pluralists. I will explain what I mean by them. They somehow acknowledge inevitability of the room for interpretation and some clashes. It's not like we, when we were born, we think about law in kind of in this archetypical way that the system must be coherent, all norms must fit perfectly into the model, and if something, of course, it cannot function perfectly, but that's why we need lawyers, and that's why we need legislators who will remedy all this problem. But it's kind of it's a pathological situation if the conflict emerges. That's our archetypical approach to law. In reality, it's normal situation. When the conflicts are inevitable, they are productive. They somehow drive the system to its further refinement. So if we talk about 50-50 cases, and if we have in competition law the leading legal minds and economic minds and data science minds and behavioral scientists, if we imagine a scenario hypothetically as an intellectual experiment, if parties swap their legal representatives, many outcomes would be different, yeah, in 50-50 cases. So at least this incremental shift can somehow recalibrate the entire outcome. And again, it's normal because we are not relying on syllogistic, deterministic vision of the pre-existing truth, which we have to discover. We create the truth. There are many coexisting outcomes which are simultaneously correct. And then it's for the parties to articulate, to tailor, to create a kind of a special course from the ingredients which are identical for all representatives. It's not a plea for somehow that everything is relative and that we have to rely on indeterminacy, that there is no benchmarks which are stable, etc. It's just a plea, a kind of a countercultural plea to somehow to abandon the belief in the absolute consistency. And it's not an attempt to somehow to say that that's how we should be. It's an observation about the reality. So in this sense, it is a descriptive thesis. So if we have different system of norms, system of values coexisting within, let's say, the Treaty on the Functioning of the European Union, we can see that, and we have to address the issue how they communicate with each other and how do we develop the protocol of prioritizing one value over the other in which specific case set of circumstances. And this is kind of an attempt which is which legal pluralism in jurisprudence or constitutional pluralism in EU law or in any kind of complex federative or confederative system try to somehow to address. And the starting point is that there is no pre-existing value, as I said, and which is very difficult for us because our mind was nurtured by a belief in a kind of modernistic fashion. We thought that there is a condition on the market which is kind of ideal, and maybe even if it's hard to achieve, it's worth to try to achieve. And however complex the reality is, our vocabulary and our apparatus is getting more and more refined with econometrics, industrial organizations, and all this, and legal casuistic indeed. We are able to somehow to pace and to catch up with this complex reality, and we are able to discover the truths. So this is a monistic approach to think. And the pluralistic say that there is more than one truth, and if you pass the minimum threshold of correctness, of legal correctness, economic correctness, and factual correctness, this minimum threshold can be very high. But if you pass it, you leave it for the judge or any decision maker to decide a genuinely hard case, relying on something which is extra legal, which is beyond the system of metrics which the parties are able to present. Obviously, if you don't match the minimum threshold, you cannot win the case. If you say, look, I think it's good to for this law being interpreted in this way, but it doesn't meet the requirement of letter of law or economic theory, then there is no chances. But the proposition of legal pluralism is that more than one answer can be the right answer. And then if we have this genuinely hard situation where more than one answer passes the threshold of legality and economic rationality and facticity, then it's for the judge to decide based on the myriad of factors, including, as legal realists would say, including on their breakfast, what they have on their personal preferences and wishes. Obviously, again, it's a descriptive thesis. It's not a plea that we have to adopt this system. It's a plea that it exists, whether we want it or not. So that context matters. And so legal pluralism, and there are different variations of it, including the most refined, the most advanced sociological approach by Niklas Luhmann with his legal autopoiesis and the systems theory, where he tries to somehow to scrutinize the protocols, how different values communicate and how we bargain essentially with each other in the myriad of circumstances. They try to address this issue in a more conceptual way. And I think that the new reality in which competition law, economics, and policy are rediscovering themselves, it would be very helpful for us to maybe to feed a little bit from this kind of more established mature disciplines, our alma maters, so to say. And the same, and even less esoteric and more relevant for competition, for EU competition law discussions we witness in constitutional pluralism, because basically what they discuss constantly, endlessly. I just want to double check, am I okay with timing?
Yeah, you still have 7 minutes left.
17 minutes.
7. 17 is
I'll be honest joke, sorry. So constitutional pluralism is more relevant for us because they constantly discuss all this kind of German constitutional court, Polish constitutional, all this stuff is coexisting of system, and there is no right answer. If you take pedantically the vision of, let's say, German constitutional court or German constitutional law, let's say, yeah, it's absolutely mature, well articulated, and convincing. The same holds true. So depending on your position and depending on within which form, within which system you operate, different solutions appear to be most convincing and logical. and they coexist. And in the European Union, it's a perpetual communication between EU legal order and our ambition to create something supranational and thus synchronous, uniform, more or less, even if diverse, and national legal orders. And they actually, at the level of the Court of Justice, already have developed very rich case law and even much richer literature on these issues, on how we communicate. And I think that it would be helpful for us to transpose the formulas which have been already discussed, which are being discussed constantly in constitutional pluralism, to our domain when we discuss, for example, the issues of sustainability or digital markets, where different visions clash with the traditional neoclassical perception of competition economics and competition law and economics. So there are three lessons, general lessons, which I think would be helpful which are helpful for me at least, and for some peers who I know who are also interested in legal theoretical aspects of competition law. The first one, that there is no predetermined taxonomy between different values. There's no hierarchy of values saying that, okay, this is of constitutional value, human rights, or this is sustainability. Every representative of each specific system of norms can somehow find the justification for their own. It's like if you imagine a very authoritarian regime, you can say that they have clear-cut hierarchy of values. In a democratic system, it's all context dependent, and each value can outweigh the neighboring one, depending on myriad of circumstances, including on the skills, on the intellectual muscles of the parties representing this specific value in this specific case. We know in competition law that, that some people who are in the past were very, aggressively kind of rational, now very prudently and elegantly present very different set of visions. So they serve different objectives, different values, and it works. And again, because it's a descriptive theory, it's not to say that it's good or bad, it's a reality. The second lesson is that it's not a jigsaw puzzle, which is kind of modernistic vision, that the reality is complex. We have 1,000 pieces, scratching our heads how to put this into kind of harmonious picture, but there is the final product. This harmonious picture is the right answer. In the pluralist modality, we have different elements of this Lego constructor, but we can create very different figures, and those different figures can be, it depends on our creativity, of judicial creativity or legal policy-making creativity. The variety of outcomes is much broader than 100%. And in the previous kind of traditional modernistic vision, we have 100% compartmentalized now on 1,000 different pieces, and we sit and put together, trying to somehow to recreate the objective truth, the reality, so to say. And another kind of solution or another kind of conclusion from this is that all values are simultaneously incommensurable and commensurable. So we need law and economics. And as I return back to the thesis that it's a relative relativism, it's not iconoclastic statement. We need single metrics, and law and economics suits best to this, but we shouldn't consider it almost religiously as the one reflecting the reality. And the kind of the bottom line of the statement is that each value has its own pathway to the pantheon of constitutional priorities. Each value has its own kind of path to Article 11, be it sustainability, or kind of too big to fail, or industrial policy. It's so important that, chips, etc., fourth industrial revolution, or the war. I'm Ukrainian. The war in Ukraine. I don't care about anything else. We have to survive. We have to kind of protect our country. Depending on the position of each specific system of norms, they can, and if you have skillful interpreters, they can escalate the arguments to the level of, let's say, constitutional treaty on the European Union, or treaty on the function of the European Union, and then it's still there is no trump card in this game, so to say. With this, I've finished. Thank you very much.
Thank you very much, Oles. Very interesting how you shed light on this topic of legal pluralism. So I will now turn to Kalpana for the discussion.
Thank you. Thank you, Oles, for that very nice presentation. I think you have a lot of work on it. So I would, instead of discussing your paper, I'll take the liberty to use the quotation exception in copyright and try to enter into a dialogue with your work. So I would refer to you back to back. Let me start with something that you started your slides with, which was that we do not have a concept of monoism which works today. It is pluralism, which means that there can be more than one truth, right? And you talk about multi-log of values, policies, interests, readings, and narratives. Now, with that background, and to make it a little bit perhaps tangible for all of us, I think the discussion and deliberation on this monocentricity started a couple of years ago. Oles has some great work on it. Way back in 2019, Professor Hovenkamp goes on to deliberate on the legacies of Chicago School, which is when the question really started raising its ugly head, if I can say, in light of digitalization. And the question was that, is the consumer welfare, which is a gift of the Chicago School, is it imperiled? So therein he starts with the book's antitrust paradox, and he forcefully argues that Bogue suggested that we should be driven by some principle and let that principle be consumer welfare. Now, when economists, and we have some of them in the room today, when they talk about welfare, what they mean is Pareto efficiency or Calder-Hicks efficiency or some concept of welfare. By contrast, when Bogue referred to this consumer welfare principle, or as we generally understand in competition policy today, what we are encouraging is higher output, competitive prices, right? Where does the problem come? Because Ole suggests us a solution to a big problem by going to pluralism. The problem is that in the approach that we have at the moment currently, not every interest gets equally represented, right? Especially, let me make it a little bit more tangible. For example, in the context of the digital economy, wherein the non-price dimensions of competition become very important, the privacy concern being one of them. Then obviously we have all those things, the rise of Internet of Things, and in your paper you also talk about Industry 4, which is kind of going to compound the problem, and therefore you also very forcefully and rightfully argue that there's a need to move to a stakeholder-driven debate and discussion instead of the current approach that we follow. So this means that we are at a touch point of reflection. What drives us to rethink many dynamics? And as I said, I think rise of the platform economy, which is also the theme for the conference, one of the central thing. And why is it important? A couple of things that we, or perhaps three patterns that we commonly identify in the context of digitalization that makes it so relevant. How we see diminished horizontal competition, how there's a control of bottleneck facilities, and what we see is the rise of proprietary digital ecosystems. And then I think third and related to this is also the capacity then to determine the architecture of the ecosystem. And I think in that respect, what your suggestion in a nutshell, and I guess I have a minute now, right, to wrap up. Yeah, a couple of minutes. Okay, then I can go a bit longer. Okay, so then because we have time, so obviously digitalization is the big culprit, and our favorite pastime, which is like which car farm to break up. But we also have other sectors wherein we have examples. For example, agriculture. This is something that we work in terms of, making agri-food sector more sustainable, wherein I have more closely looked at how for example, our current merger control framework works, and perhaps particularly in regard, because we had many 6-4 mergers and the sector is highly concentrated today. We had 3 back-to-back big mergers, and which is why we call it a 6-4 concentration. So we don't call it 6-5 mergers, but 6-4. And in fact, the remedies in one of them, I think it was the Baum Monsanto, wherein the remedies were so huge that was itself subject to merger control, merger review in some of the jurisdictions. And then I think Oles' question becomes all the more endemic to the debate, and Professor Leonis also has some work on it, the 2018 paper, Polycentric Competition Policy. The question is then, should we transcend from a monocentric view of competition law towards a polycentric view of competition law? If that is the thing, then what should be the contours, or what should be the finer outlines of one such competition policy? But at the same time, and I'm sure there are very many different balancing interests at stake, what also needs to be kept in mind, there are some things that our current approach does well. So for example, if I look at the unilateral effects of mergers in horizontal, like, in concentrations, if I'm looking at innovation spaces, something that was also looked at in many of the mergers in the food agri-food sector, like for example, Dow-DuPont merger, the commission went at great lengths to examine innovation competition, both at the level of innovation spaces within the crop protection industry and also at the industry level. It addressed the issues to a certain extent. And with that, I wrap up. But there were issues that still remain unaddressed. And as an example, the number of interest groups, the consumers who came forward and suggested that the merger be prohibited. Nonetheless, it was conditionally allowed. So I do stand for your polycentric view. So you have a vote there. Thank you.
Okay, thanks a lot, Kalpana, for building on Ole's presentation and also giving us some concrete cases to illustrate what indeed the ideas here could mean in practice. So I'm happy now to open the floor for questions, and I will later on also, maybe Oles, if you like to react to Kalpana, also allow you to do that. But let me first see. I think there is a question from Julian.
Hey, Oles, Julian here. Good seeing you. You can't see me, but I can see you. That's already something. Thanks a lot. Interesting presentation as always. I was just thinking, and I think sometimes they're the different. You can actually see me possibly now. The debate might be slightly different in competition law than it is in constitutional pluralism, because in a certain way, the starting point is different. At least, like, if you think about Europe, I can understand how we can use pluralism maybe to explain the global debates about competition law. And I think it might be super helpful to think about the goals of competition law in that regard, maybe that debate in terms of pluralism. It makes a lot of sense. If you give me the example of digital and sustainability, I'm a bit more I should say, reserved in accepting that as a principle, as a good example. Why is that? Because I think that might actually lead to less discussion rather than more discussion. Less discussion in the sense it might explain things, but I think there is still, at least from the area of sustainability, there is still so much misunderstanding. I think it's getting better. Misunderstanding about the actual areas where people do agree. And I think people discuss this topic quite a lot, and then they focus on the out-of-market efficiencies and whatever. And there I think it is helpful. But I'm a bit worried whether it ends up in saying, well, you have that, I have that, and let's agree to disagree, kind of situation, that you don't discuss anymore the core of contestability and actually find, well, maybe there are not that many areas where there is disagreement. So that's just a reflection, maybe more than a question.
Oles, would you like to respond?
I'm afraid my response will be very short, because I think these reflections are very accurate. So I think I agree with this point. I think this is a shortcoming of this approach, because it somehow, and that's a task for me to refine it, because it obviously I make it a kind of a reservation. It's a descriptive thesis. It's not a plea for the need of such kind of relativism. But if we somehow nurture it further, and if we try to look at the current processes through this lens, there is a danger of saying, okay, everything is relative, all values in one way or another merit their promotion, and it's everything is rock, paper, scissors, and whatever decision you make, you can justify it. I acknowledge it's a kind of it's a shortcoming of this approach, and I will try to deal with this.
Are there other questions? No, then let me ask you a question. So one of the things you pointed out, I think it was at the beginning of your presentations, that there is different legal values and that courts also have a difficult time to weigh evidence because there's different views and it's not so easy to tell which one is correct or not. So how can we then learn from different approaches? So would you agree that experimentation is good? So maybe different, for instance, in the competition context, different competition authorities taking different outcomes and using that to, in the long term, then see which approach has affected the market, and then to compare, and then maybe at a longer term have a better view of what is the right value, of what is the desirable way of developing competition law, or how do you see this clash in values, maybe also as an advantage that we can learn and make competition law better?
Yeah, thank you very much, Inge. And I think this links to very well with what has been articulated by my excellent fellow discussant of the paper, and I'm very grateful to Kalpi for her comments. So I think it is. Because I was trying to put it as a counter theory, as an attempt to somehow to say, look, there is no universal or absolute truth behind these processes, and it's inherently political. The decisions are hard cases. In 99%, those are which are not problematized, which are self-executing, we leave them aside. We're interested in hard cases where the room for interpretation is decisive. And I think it will be, the trick is, and I heard it by raised by some colleagues from German competition law, those who promote the article section 19a escalation, is that okay? So as long as the Commission, DGJ, are determined to pursue digital policy in the right way, we are happy with this. But we need some safety net in case if the management changes and the priorities changes, and they will start doing it in the way, I don't want to say which one, but in the one which would be against our vision of how digital should be regulated in the 21st century, then we need some. So the reliance on experimentalism and all this kind of regulatory sandbox and future-proof regulation, to a large degree, depends on to what extent it coincides with your normative priorities. If they go in line with your personal preferences, you're all in favor of all this discretionary power for competition authorities, saying, yes, there is no textbook answer to these questions. Let's them learn their own mistakes for this kind of ex ante sui generis competition law sensu lato. If you advocate more conservative values, then it probably make, and particularly coming from traditional juristic or traditional neoclassical economic background, it would make you furious, saying, look, it's these ideas and conflicts is the basic foundational values of our disciplines, legal certainty and economic predictability, and both these approaches are equally acceptable by this legal pluralism, because as Julian noted, the side effect of it can somehow tolerate everything. It's too kind of pacifistic, saying, yeah, it's kind of meditative, saying, yeah, okay, if the court decides this, then this is the truth. As a descriptive thesis, I think it actually represents the reality, maybe a little bit in a little bit more frivolous fashion as it should. But obviously, I wouldn't try to promote it as a normative proposition. Thank you.
Okay, thanks a lot, Oles, for this very interesting first part of our session. So I will then move on to the second presentation by Rosa Baum, who is an associate at the law firm Brownstein Hyatt Farber Schreck, and who will be speaking about US competition law and digital markets.
Perfect. All right, I will get started. Can everyone hear me? Okay, fantastic. Thank you so much for having me. My name is Rosa. I'm an attorney from the US. I practice in Denver, Colorado. And it's an absolute honor to be here. Thank you so much for the invitation. I want to focus my presentation on US competition law and the digital markets. And basically with this chapter that I wrote with one of the partners of my law firm, Alan Grudis, we traced, we looked at why, as rightly characterized yesterday in one of the presentations, the US is really the backward outlier of the parties that we're talking about, or many of the parties that we're talking about. And so from what we've seen is really the story in, there we go. The story in the US essentially chronicles how, after successfully challenging Microsoft's monopolization of the operating system market, the US settled into a period of relative inactivity. And it's during that point that the current crop of tech firms emerged, achieved their dominance in their respective core markets, and took steps to then limit or exclude other competition. And it's really only until recently that the U.S. Department of Justice, the DOJ, as I'll be referring to it, and the Federal Trade Commission, the FTC, have begun to take more significant enforcement actions in this sector. So I'm sure everyone here knows US v. Microsoft, which is a quick background. The DOJ sued Microsoft for its use of its internet browser, Internet Explorer, to protect Microsoft's power in the PC operating systems in the 1990s. Microsoft basically made it exceedingly hard for Netscape to encroach upon its power here, and so consumers really weren't able to use Netscape and break into that Microsoft operating system. In the Court of Appeals for the District Court of Columbia, in their decision, it really ultimately came out to be a balance. The court seemed to be going for a balance on the one side of deference to tech firms when it came to the design of their choices in creating new products, but also for updating existing products. So that was on the one side. On the other hand, we saw the application of antitrust to a zero price product, network effects and barriers to entry, and critically, the importance of scale to digital competition. Ultimately, liability in the case wasn't based on self-preferencing, but rather on this conduct that prevented Netscape from achieving the scale necessary to really compete with Microsoft in the operating system. As Senator Richard Blumenthal and Tim Wu have specifically pointed out, the beneficiaries of the decision in Microsoft were the tech behemoths that today have grown to be quite large in their own right. So then we move into this period of a decline in enforcement. And we think that the poster child of this period is the FTC's 2011 to 13 investigations of allegations made against Google that the company was anti-competitively promoting its own vertical properties through alterations in its search results page. Fast forward to 2015, actually some portions of an FTC staff memo were leaked and published. And it turned out that the staff memo actually recommended the FTC bring legal action against the conduct, but the commission ultimately decided not to take any such action. Other examples that kind of outlined or that really show this period is Google's 2007 acquisition of DoubleClick and Facebook's 2014 acquisition of WhatsApp. So this reasonably cues the question of, is there an explanation in drop-off in this enforcement? As everyone in this room, I'm sure, has heard, so many of these arguments center around the statements that competition in the digital era is dynamic, static, that we're looking at competition for the market rather than in the market, that such competition can merely be expected to result in one large firm or a few large firms really dominating. And that the drivers of innovation are really not as well understood as, say, the economics of price. At least in the US, which is home to many of the large tech firms. So we know these arguments have truly resonated. And of course, tech firms have not shied away from also utilizing other avenues to get their points across, including aggressive lobbying and contributions to like-minded institutions and individuals. For example, Bloomberg reported that Alphabet, Meta, Apple, and Amazon, as well as their trade organizations, all spent hundreds of millions of dollars to quash many of the legislative proposals that have recently come up for discussion. So as everyone in this room is aware, 2019 saw 3 major reports come out, but critically, only 2 were prepared at the direction of government officials. It's quite telling that that was not the case for the report on the US. It's not to say that US government officials aren't interested in competition law developments. For example, the head of the FTC, Lena Khan, and the head of the DOJ Antitrust Division, Jonathan Cantor, have both publicly criticized the consumer welfare standard, and President Biden came out recently and said that the current view of antitrust has been a, and I quote, failed experiment. President Biden also recently issued an executive order that adopts a whole of government approach when it comes to antitrust enforcement, which basically means that he's enlisting all of the agencies, not just the FTC and the DOJ, to really try and use each agency's authority to police anti-competitive conduct within each agency's jurisdiction. But still, change is unlikely, and that's kind of where we ended, or how we've gotten to where we are with, again, the US being a backwards outlier. And some key aspects, I'm going to go through some key aspects, but this is by no means an exhaustive list, unfortunately. So the first is the 1976 Hart-Scott-Rodino Antitrust Improvements Act, which establishes the US's pre-merger notification program. So it's relevant to our discussion here. The act exempts from review transactions that are valued at less than $50 million, and technology mergers often fall below this line. And so it creates this twilight zone where that increasingly benefits these large tech platforms, since they hold asymmetrical knowledge regarding small competitors and can easily acquire these competitors without any sort of review. In fact, I'm sure as many of you know, Facebook has harnessed the ability to spot these nascent competitors through its acquisition of the mobile phone monitoring Onavo. Similarly, several decisions coming out of the US judicial system have carved out a specific preferential treatment of high-tech questions. So while rightfully so, Microsoft, the decision is lauded as ahead of its time in anticipating the dangers that digital markets pose to specifically competition, aspects of the case arguably negatively impacted efforts to take on big tech. So the Microsoft decision actually dodged the question as to the applicability of the per se rule to the government's claim that Microsoft had tied Internet Explorer and Windows and thus violated the Sherman Act. So this ultimately likely didn't affect the outcome of the case itself, but it arguably broke with US precedent. Again, this wasn't a US Supreme Court decision in which the US Supreme Court had previously held that ties meeting several economic criteria were per se unlawful. And the court explained or reasoned that it had broken with this line of cases, basically saying that applying a per se analysis to software serving as a platform for third-party applications created, and I quote, undue risks of error and of deterring welfare-enhancing innovation, end quote, and that, quote, the nature of the platform software market affirmatively suggests that per se rules might stunt valuable innovation. This sort of special treatment continued in 2004 with the US Supreme Court's decision in Verizon versus Trinco. Quick background, Trinco sued Verizon under the 1996 Telecommunications Act and Sherman Act Section 2, claiming that Verizon was discriminating against rivals and in its efforts to refuse to supply them with network connections. So rather than require that Verizon prove it had a legitimate justification for not dealing with this telecom competitor, Justice Antonin Scalia's majority opinion held that Verizon didn't have any such duty. He reasoned that this conclusion safeguarded, and I quote, the incentive to innovate. So again, it's a reversion to the very nature of the questions that are being dealt with. But Justice Scalia's conclusion ignored the balance between limiting a competitor's duty to share and condemning a dominant firm's conduct, exclusionary conduct, all in the name in incentivizing innovation, had already been struck in the court's previous duty to deal cases. Last big Supreme Court case, I promise. And most recently in Ohio versus American Express, the DOJ challenged various credit card anti-steering provisions. Much of the focus in this Amex litigation rested on the market definition that was up for consideration, and like digital platforms, we're talking about two-sided markets. And instead of recognizing direct evidence of anti-competitive actual fee increases derivative of this practice, the court instead held that the government had to show that the net price, which included that paid by the merchant and the potentially negative price, so essentially the benefit that the consumer received in the two-sided market, had increased. So relying on the increasing volume of credit card usage, the majority characterized the Amex fee as competition on the merits because it supported larger user rewards. So, potential for change, potentially. 2 minutes. Wow, that went fast. Okay, so I'll just tick through a couple things. There have been some developments in the US. So for example, we had the Merger Filing Fee and Modernization Act, which updated the merger fees, which we had not updated since 2001. So pretty obvious that we needed to make those updates. There are some frustrations, obviously, with agency enforcement. For example, the recent decision to drop the challenge, to Meta's acquisition of Within Unlimited is a loss, but there are, and just to highlight 2 specific challenges that are currently pending. So a January 2023 challenge to Google's conduct in the ad industry, and then just earlier this week on Wednesday, if anyone was following that, the FTC brought action against Amazon for their use of different techniques to basically get people to subscribe for Prime and then make it nearly impossible to get out of those subscriptions. One thing I do want to quickly mention is we aren't only in this area of deadlock. We aren't just looking at specific sections of the regulation directly of antitrust law in the US. There are also external factors that are impacting the US acting on these questions. So the US Supreme Court recently decided to review the Chevron doctrine, which is basically the doctrine that gives deference to agency interpretations of their governing statutes. The FTC rarely uses this power. There are actually a lot of questions, or there are some questions brought up by more politically conservative individuals as to whether the FTC actually has this power. We're of the mind that it does, but if the US Supreme Court were to do away with the Chevron doctrine, this would close an avenue that Chairwoman Khan has recently talked about utilizing. 2 quick pieces of legislation that I want to mention. The first is the American Innovation and Choice Online Act. which is also known as the Klobuchar bill. I'll just come out and say quickly, this was not passed. It came out of committee and had bipartisan support, but did not yield any concrete action. This is akin to the DMA in that it focuses on gatekeepers and at its core is a digital platform non-discrimination act. One slight difference is that it does retain affirmative defenses for those entities that it covers. Another really interesting piece of legislation is the Journalism Competition and Protection Act. Again, it did not pass. So this carves out an exemption specifically for news publishers to collectively bargain with digital platforms. This was specifically frustrating, I think, across the US because we saw these same provisions, or essentially the same provisions, engage Australia and Facebook in a battle in their own right, and Australia came out victorious, really. Facebook took down its news feed in the country for a while, and now it's back up. But in the US, we did not take the step. Instead, we cowered to the pressures of Facebook. And again, even though this piece of legislation had bipartisan support, had support, as a note up there, from tech giants like Microsoft, it did not ultimately pass. So to quickly conclude, as I think is evident, the outlook for substantial update to US competition law to meet the challenges of digital markets is easily to say uncertain, but as these platforms themselves have shown, conventional boundaries and frontiers don't seem to mean as much as they did when we solely operated out of brick and mortar stores. So while the DMA theoretically only operates within the EU, there is opportunity for gatekeepers to be forced to, or even prefer to, really align their global business models with the DMA so they aren't managing diverging lines of effort. Said much is left unclear, but what is evident, as my co-author Alan Grudis and I would argue, is that US digital platforms have been able to frame policy discussions in the US to focus on the benefits that they provide for their users. So the discourse has been around the technology and development and innovation. Comparatively, we have not yet arrived at the EU's discussion of the scrutiny that is expanded to the effect of technology. And as a concluding point, this practice of the US approaching but then receding from regulation puts it in a position of ceding the opportunity to another global player, EU, for example, to lead the charge in regulations that are ultimately really going to impact US companies.
Thank you. Thank you, Rosa, for this very comprehensive review of the developments in the US. It's interesting to see similarities in ideas, but not yet when it comes to implementation. So let's see what happens in the future. So I will now pass the floor to Caroline Cauffman, who is an associate professor here at Maastricht University, for the discussion of the paper.
Thank you, Mrs. Chairwoman. Thank you also, Rosa, for sharing with us your valuable insights into the developments in the US with regard to the regulation of digital markets. When reading your paper, my thoughts went about how we explain the fact that the US has traditionally been a front runner in digitalization, in digital markets, that the biggest digital platforms have their main place of business in the US, and nevertheless, it is the EU that is the front runner in regulation, in the regulation of digital markets. And after considering this for a while, I came to the conclusion that it might not be so surprising that this is the situation, that the EU is taking the lead in the regulation of digital markets, and in particular in adopting legislative instruments for this purpose. First of all, the EU consists mainly of legal systems that belong to the civil law tradition, which have a preference for laying down legal rules in legislative instruments rather than leaving it to the courts to develop rules for new legal problems when they arise. And secondly, the EU has always taken a more favorable position towards the regulation of markets than the US. The US is very strict in following the idea of free competition, free enterprise, and in the EU, the situation is more moderate. Free competition is considered as an essential element of the internal market, but the EU does not pursue a free market economy pur sang. It pursues a social market economy where other values than economic efficiency are also considered to be important. Values like privacy, consumer protection, protection of SMEs, etc. Moreover, EU competition law is influenced by the idea that market structure has an important impact on competition and is more inclined to see the risks of abuse of market dominance, while the US, in any case since the 1970s, has put more stress on the fact that market dominance can also be beneficial, and it has been reluctant and not very successful to take action against monopolies. Speaker also mentioned that the digital industry has been very active in highlighting the benefits of digitalization, and invested in lobbying and trying to impact the behavior of the lawmaker. But as you mentioned, what happens in the EU does not stay in the EU. When US companies target European markets, offer goods and services on digital markets in the EU, they also have to comply with EU legislation. And I would wonder, therefore, whether they do not also invest in lobbying new institutions and trying to influence the behavior of the European lawmaker. And if they do, why they are less successful in achieving their purpose. This is my first question for you, Rosa. Do you believe that the differences in the approach to the regulation of digital markets in the EU and US are mainly due to the intensity and the success of lobbying activities of the industry, or can be explained more by the underlying values and thoughts about the role of competition law and digitalization and regulation of the markets in general? And then my second question is more an informational question. I would like to hear a bit more about this general.
Okay, thanks a lot for those comments. Yeah. So let me first see if there's other questions from the room before Rosa giving you back the floor to also address some of the questions that Caroline posed to you. Other questions? Yeah, Julia.
Sorry, I have actually 3 points. So the first one is a very quick question. The second one is a question. The third one is a comment where I wanted to hear your thoughts. So the first one relates, you said there's an increase in agency funding, I think 85 million or so. I was last year at the FTC, and I just like, if you go inside that building and into the offices, this place looks luxurious, like very luxurious against it. It's like, I don't know how some people can work in them. So I was wondering, is it for both agencies or just for the FTC or the DOJ part? Then do you think there's going to be new regulation coming, or is that window closed now? And then the third one is, you were so critical, or seemed a bit critical, of the evolution of the per se approach. I'm always thinking, if you take a per se approach, that's really, if we use the European term, it's really not taking into account effects or whatever. It's a very kind of formalistic approach. So I was thinking whether the problem is much more related to procedural matters, rather how the rule of reason currently is applied in the context of the US, and that possibly has much more to do not necessarily with the antitrust per se, but with the procedural things that are more in the surrounding of antitrust. So I always wanted to hear your comment on that.
Thanks a lot for those points. I think I will pass back the floor to you, Rosa. I think you have 5 questions to answer, so it's quite a lot.
Perfect. Okay, thank you so much for all of the questions. First, kind of a response and also reflection on some of the things that Carolina mentioned. I think the adjudication or case-by-case adjudication as compared to more of legislative rulemaking definitely does have a large impact. And that's something that Rohit Chopra and Lina Khan have recently talked about in an article that they wrote, I believe, in 2020, arguing that if the FTC were to use, and this goes back to the Chevron doctrine, so I'll try and pull that all together. If the FTC were to use more substantive rulemaking powers, then that could better provide essentially administrable standards in the US, that this case-by-case administration that we've really taken on results in difficult, in the courts administrating these standards that are difficult to yield predictable results. And so that's why we've had kind of this haphazard patchwork of different results in cases that have left many to just kind of extract legal rules from these different considerations and court questions that haven't, I think, resulted in an administrable way of dealing with antitrust questions in the United States. On the question as to whether I think that regulation in the US or competition law in the US is less successful because of lobbying or more of the underlying values, I definitely think it's both. I would tend to, it's hard to say which one is stronger. I don't want to undercount either of them. Lobbying arms of these trade groups are incredibly powerful. It's really problematic how much money is in the US legal system. And I definitely think that that is a place that needs much reform. I unfortunately don't see that happening anytime soon, but that would be an area that I would like to address. But I do think that also these underlying values are have a strong hold in the US. So Professor Hovenkamp was mentioned earlier by Kalpana, and he's an incredibly well-respected academic in the US, and he has repeatedly said, no, the consumer welfare protection, the consumer welfare standard is not imperiled, and we're not going to move away from this anytime soon. So I think that they're acting in tandem, attacking from different perspectives the idea that we could have some sort of reform in the US. I would love to look into whether lobbying in the US, or why lobbying in the US, or sorry, in the EU is seemingly less successful. I think that's a fascinating idea. Maybe that will be a next focus, but I couldn't tell you. As to the Chevron doctrine, to tie it back to my comments earlier, so the Chevron doctrine provides judicial deference, as I was saying, to reasonable agency interpretations and determinations. And this doctrine basically, it doesn't cede because it's not an abdication, but it provides deference to expert determinations in the agencies of the administrative state in the US. So it says that courts aren't necessarily the best positioned institutions to decide how to best regulate an industry, but that is currently up for debate, unfortunately, in the US. So if the Supreme Court were to pull back on the deference that is given to the administrative state, which is a target, or which is a driving force behind several justices of the Supreme Court, Neil Gorsuch to name probably the most prominent, it is likely that there is going to be some sort of pulling back on that, not leeway, but deference to the experts that the US currently provides. The funding, the $85 million, it's to DOJ and the FTC. So it is split up. I believe it's 35-50, but I'm not 100% sure. I'd have to double check on that. New regulations, whether they're likely, it is likely that the Klobuchar bill is going to be reintroduced. Whether it's going to be passed, point you unfortunately to the deadlock that's occurring right now. And for your comments on the per se approach, I was just focusing on how US law has, or the US courts have treated the tech industry so differently. So not necessarily a comment on the two different approaches, but the carve out in how the high tech industry has been treated so differently than so many other balances that had already been struck in the US courts. That this incentive to innovate has kind of been we can't apply what we apply elsewhere to this area because of the very nature of the underlying question.
Okay, thanks a lot. Thanks so much for this very interesting discussion. So with that, I'm going to move to the third presentation by Thomas Graf, who is a partner at the law firm Cleary Gottlieb, and who will speak to us about data algorithms and competition law. So we, of course, stay in the digital setting.
Okay. Morning, many thanks. So I prepared a paper where I explore a little bit the boundaries between lawful competition and abusive behavior, and where to draw the lines between the two. And my main two propositions that I advance in the paper are, first, there is a necessary analytical step in the examination of Article 102, where the regulator needs to look or needs to assess whether the conduct of the dominant company deviates from competition on the merits. So that's a necessary step in the analysis. And then second, what does it mean to deviate from competition on the merits? Here, some recent case law provides guidance, and my proposition is that there is sort of a generalized principle that deviation from competition on the merits arises when the dominant firm acts predatorily. It acts against its own economic interests, so it's irrational, but for the interest in foreclosing competition. And that's what I am going to explore a little bit here in this presentation. So the first step, deviation from competitional merits, is it a necessary element in the analysis of Article 102 of the treaty? If you look at sort of the debate around abuse over the last 5-10 years, the focus has been very much on effects. The concept of deviation from competition on the merits has been there for a long time. If you go back in the case law, it was one of the first cases, Cauffman La Roche. It uses the concept of departure from normal competition. Doesn't explain what that is, but it's there. And then in some later cases, like AXA, this concept of deviation from competition on the merits comes up. But the case law didn't really explore how that fits in the analytical framework. As I said, the main focus was really on the question of effect. And for a long time, sort of the traditional application was we look at the nature of the behavior, and then that's enough, and there is an abuse. And so the debate was about, do we not need also to show restrictive effects? And that's where much of the discussion was. And you have now sort of a series of more recent cases which make clear that yes, effects is a necessary element of the analysis. The Commission, the Competition Authority needs to prove that a likely competitive effects, likely restrictive effects, doesn't need to prove actual effects, but at least the probability that restrictive effects will arise. But the debate on how do we actually assess the conduct, that hasn't been very much in the case law, up to the Google shopping case, where this debate was really at the focus of the discussion. And I should say I represented Google in that case, so you get my perspective on this. But we can certainly have a debate in the discussion. And so in the Google shopping case, you see portions of the decision which seem to suggest that basically what made the conduct abusive were its effects. You have this paragraph 341 in the decision where the Commission explains Google's conduct was abusive and it deviated from competition on the merits because its conduct took place in search and it had effects in another market. And in other portions of the decision, this is referred to as leveraging. So the abuse was the consequence of leveraging, or that arose because there was leveraging, because Google's behavior in search had this restrictive effect in comparison shopping in a neighboring market in that case. And so when the case came up on appeal before the General Court, there was a question around, well, is that really enough? Is it enough to call conduct leveraging? Is it enough if the conduct of a dominant firm or the digital platform has restrictive effects, has exclusionary effects in another market? And the argument was that cannot be sufficient because it had been established in prior case law that conduct that is competition on the merits can also have exclusionary effects. And it's also in the Commission's own abuse guidelines, and it was established in Denmark. The Court of Justice said, no, just because there is an exclusion, that's not enough for an abuse, because if you compete on the price, if you compete on quality, rivals can exit the market too. And the same is true, and I think that was the important sort of insight in shopping. The same can be true in an leveraging case. The platform can compete on the merits in the platform market. That may have exclusionary effects in some other market. Potentially, if the platform innovates, if it improves the platform, that may have knock-on effects. And so just calling something leveraging or just observing that there may be exclusionary effects in another market, that seems not to be enough. And that was the argument. And the General Court, in principle, accepted the argument. It makes very clear that you cannot just refer to conduct as leveraging to characterize it as abusive. Leveraging is sort of a generic term that simply describes that there is conduct in one market, that there's an effect in another market, but on its own, absent proof that the conduct is anti-competitive, that is not sufficient. And it also made clear that sort of deriving the anti-competitive nature of the conduct from the effects, that is not sufficient. Right? And so, it recognized that this paragraph 341 was a bit ambiguous at the very least in this respect. The court then went on and saved the Commission and said, no, but there are other passages in the decision which actually explain why the conduct is abusive, why it is a deviation from conditional merits. We disagree on that. That's the topic of the appeal now before the Court of Justice. It's like the legal question, were these criteria that the court identified in the decision, were they sufficient for establishing a deviation from competition on the merits or not? So that's in on debate, but the key takeaway from the General Court judgment is that yes, the question of the nature of the conduct is important too. It's not a dichotomy where I say either nature or effect. You need to look at the nature of the conduct and say, is there a deviation from competition on the merits, and does it have restrictive effect? And these are two steps in the analysis, and they cannot be sort of combined or melded into one. They are separate. And that was also recently confirmed by the Court of Justice in the Servizio case. That's a case that involved the Italian electricity utility that enjoyed a protected monopoly in one area, and it was actually a data case. Even so, it's an electricity world economy. It's also data. So the data cases come up everywhere. And in that case, the Italian utility, it was relying on customer data from the protected monopoly to compete in the liberalized. So the question was, is that a problem? And one of the questions that were put to the Court of Justice is, do we need a deviation from competition on the merits and restrictive effects? And the court says, yes, you need to establish both deviation from competition on the merits and the restrictive effects. So the analytical framework, just briefly, so looks like shown on the slide. If we apply Article 102, we need to establish dominance. We do need to show that the conduct is non-meritorious, and then we need to show that that non-meritorious conduct has restrictive effects, so there's a causal connection between the two, and that there's still a chance for the dominant company to present objective justification. That almost never works in European law. In the US, they are more open to that, but in Europe, I think that often it's done at the end, and then you have an infringement. So now, obviously, the question, what is then a deviation from competition on the merits? Right? As I mentioned, sort of in the early case, there are references in the Commission's guidance paper. There's sort of reference to competition on price, competition on quality, choice, innovation. These are given as examples of what competition on the merits can be. But actually, if you sort of look a little bit closer, it's also, that's a bit ambiguous, because as we know, you can also have an abuse in pricing behavior. So not all pricing is necessarily competition on the merits. Likewise, you can have innovation that is not necessarily competition on the merits, so that some might call innovation and others might call an abuse. And Microsoft, in the media player case, Microsoft argued that's all the bundling was beautiful innovation, and the courts disagreed. They showed that it was an abuse. So how can we establish, sort of what are the most general criteria to establish what deviation of competition on the merits is? And here again, the Servizio case offers some additional guidance in my mind. It is not a model of clarity to judgment in terms of how it is written, but sort of if you distill a little bit what it is saying, I think it's like basically applying a two-pronged test. And the general prong, the first prong of this test is a predation or predation-like test. What the court says is a deviation of competition on the merits arises if the dominant firm engages in conduct that holds no economic interest for the dominant firm, but for the foreclosure. So that's sort of the expression of predation. It's an expression of acting irrationally, but for the interest in foreclosure. And obviously, that kind of test that has always been there for pricing abuses. So predatory pricing, of course, also in margin squeezing. If you look at margin squeezing case law, for example, Telia Sonera makes very clear that this is predatory behavior, because it's not rational for the platform or the utility to price in the way that it results in a margin squeeze, because it's going to leave profit on the table. Right? To be more profitable, to actually enable the sale rather than making it a margin squeeze. So these are in pricing, it's well established. The underlying idea, the standard is predation test, is a predation test. But I think what Servicio makes clear is that we can apply this test also in non-progressive behavior. So it's a generalized test. And obviously, the mechanics of how you apply are different. You don't look at prices, you don't look at costs, but you ask, would a non-dominant firm in the shoes, dominant firm or in a platform in the digital space, would they act in this way, absent the interest to foreclose? Is it rational for the platform to act like that? And you have a nice example where actually this kind of test was applied already before the Servicio case in the Baltic rail case, where the issue was that the incumbent rail operator in Latvia, I think, or Lithuania, one of the Baltic states, had destroyed a piece of train track to prevent its competitor to benefit from the connection between the two railway systems. So suddenly a piece of train track disappeared between these two systems. And the other general point out that this is actually acting against the economic interest of the train track operator. It was not rational to operate like that, but for the interest in foreclosing the rival transport company. And so this, I think that's a nice example of the predation test in application in a non-price area. You have earlier case law, but this was not explicitly spelled out in this way, but you can see how it works. I mentioned the Microsoft Media Player case. In that case, you see there is a detailed assessment in the Commission decision around the quality of the Microsoft Media Player versus rival media players. And the Commission finds that the rival media players were actually qualitatively superior, and OEMs preferred to combine Windows with these third-party media players prior to the time. And then Microsoft came and bundled its media player qualitatively inferior with Windows. And what that basically meant is that Microsoft was degrading the quality of the bundle, degrading Windows. So if Microsoft would have looked only at Windows, then it would have been in its interest to leave the ability to combine Windows with these superior media players, but instead it chose to force OEMs to take its inferior media player, which degraded the quality of the platform ultimately. And so that's, again, you can sort of think of this as irrational behavior in terms of acting as a platform versus pursuing a strategic interest in foreclosing competition.
You have 2 minutes left.
Okay, well, almost 10 minutes. And so indeed, so that's in my mind is sort of a generalized test. Is the platform acting rationally as a platform, or is it actually acting predatorily with a strategic interest in foreclosing? Now, the Servicio judgment also mentions a second possible test, which is whether the dominant firm relies on resources that are inherent in a dominant position. And that's a bit cryptic, and so, what does that mean? But if you look at the discussion of the judgment, the court seems to have basically two scenarios in mind, two exceptional scenarios. So this says that the exception to the generalized test. The first scenario is a refusal to supply an indispensable input that is impossible to replicate. Yeah, that's sort of the Bronner test for refusal to supply, and indeed, that scenario would not work under the predation test because it's generally rational not to supply your inputs to your rivals. That's perfectly rational. That's not predation, but here it's like exceptionally, if it is indispensable, if it is impossible to replicate, there European antitrust law, not US antitrust law, says, well, we do need to supply it. But that's why because it's an exception, it's subject to a higher bar. And then the other exception that the code mentions is when the dominant firm relies on resources that derive from a statutory monopoly. That was the situation in Servicio, where the Italian utility, it was relying on this customer data that it had from its statutory monopoly. And so that's the court found that's what made it abusive, because it was relying on these exclusive rights given to it by the government. Okay, so then I conclude. Last slide, just a little outlook. So we have our test. What does this all mean on the new world of the DMA? You have now categorical rules for the very large platforms where you don't need to show abuse, you don't need to show effects. So all this analysis, in some sense, goes out of the window for the gatekeeper platforms. But obviously, there are platforms that may reach dominance level, but are not gatekeepers. And for them, obviously, that remains relevant, or in areas that are not regulated by the DMA, because DMA doesn't regulate all behavior. But so that the question is then, for me, one question is, these rules that are now in the DMA, can they be sort of taken as examples of abusive behavior? Or do they codify kind of generalized abusive behavior? I would put a question mark on this, because the abuse, it is context dependent, it is a facts dependent analysis, and it's not clear, some of these rules that the DMA codifies or embodies, is actually, you could argue that what they are trying to do is going beyond 102. If you look at recitals 10 and 11, it says like it pursues different objectives of antitrust rules. So I think we cannot just generally conclude that because a rule is in the DMA, that would now mean that if a dominant firm outside the DMA engages in that behavior that is prohibited by the DMA, that is automatically an abuse or a deviation of competition domain. So the contrary, the legislators thought it necessary to legislate it specifically, so perhaps even presume that it's not necessarily an abuse. Thank you.
Thanks a lot. Very interesting review of the case law in the EU. So it's nice that we have the US and the EU perspective on one panel. So I'm now happy to give the floor to Justine Haekens, who is a PhD candidate at the KU Leuven, for the discussion.
Thank you. Yes, thank you very much for your very interesting presentation and interesting paper as well. I found very interesting to hear your perspective on the Google shopping case, of course, since you were the lawyer defending Google in this matter, and maybe have a bit of a more critical perspective on it than certain other authors have done in the literature. And I agree that the judgment has failed to give lots of necessary clarity on different matters in this regard. I think it also ties in a bit to the what we see with recent cases, that the concept or the list of abuses is really ever expanding. Recently, the Tyagi case that revived the idea of mergers as a form of abuse, again, broadened whatever could be an abuse even more. And indeed, also with the DMA, this will continue to be a very interesting discussion, as the self-preferencing definition in the DMA in Article 6 is also very vague, and maybe a clearer tests in the Google shopping case could have avoided that discussion a little bit. But unfortunately, of course, we're left with what the court told us. So I'd like to go in a bit more on the leveraging tests, specifically then for self-referencing, what the court said in Google shopping and how you described it. So I think the competition on the merits thing is very difficult to see how that would work in case of platforms, because of course for pricing behavior, it might be a bit more easy to measure and see differences, because you could look at the marginal costs or the total costs, which is of course not very possible for a platform and for quality especially. Also looking at the railway case, I think in that case it was very clear that the behavior had no economic sense, but for other behavior it might be more difficult, because here it was really destructing a part of their own property. Whereas, for example, what Google did, it's much more nuanced, I think, the view in what they did and how it impacts their competitors. So I think the tests, of course, that the court gave was very unclear, and actually it's not clear at all what the conditions would be that they imposed here. Rather seem to say that the conditions was right in what it did, but not really give any clarity for further cases. So hopefully the Court of Justice might provide more clarity on the matter. But I was thinking, as you mentioned, the post-Denmark case as well, couldn't a similar AEC test provide more guidance in cases such as self-preferencing, so that we put it in a bit of a different perspective from the company's view, because I had some difficulties with what you call the rationality test and whether there is economic sense in behaving a certain way, because I think that would be difficult to estimate, especially from a competition authority's perspective. They would really be putting themselves in quite the business strategy of a firm, which I think might be quite difficult and leave lots of room for discussion, which would not really improve legal certainty on this matter. Or couldn't we go to the differential treatment tests, looking at whether there was a difference in treatment and whether this placed others at a competitive disadvantage, which I think might be a bit more easy to estimate for competition authorities and also for platforms to estimate whether or not their behavior would be found abusive. So I was wondering whether you could say, wouldn't that be more of a well-established legal framework setting out relevant required elements for the unlawful self-preferencing practice? Although I do think that in that case, maybe the Google Shopping case was, or at least the Commission was right, if we would apply those two criteria, because it did place others, comparative shopping services, at a competitive disadvantage, since they were not being displaced at a very prominent place and not as nicely, let's say, as the Google's service. So I was wondering whether those tests would be a solution to this issue, and maybe also a bit easier to not have too many different tests for too many different abuses in competition law. And then I also have a question on the Amazon case, which I thought was also very interesting. And I think it's a bit unfortunate that we don't have a court judgment here, because it might have provided more clarity in this matter as well, especially because the way I saw it here, it was I'm not sure whether it's two forms of abusives that the Commission was trying to prevent, because there is both the leveraging and self-preferencing aspect, but also the misuse of data. And I was wondering whether you could elaborate, do you think that this would be seen as two different forms of abuses, or is the misuse of data rather a part of the leveraging abuse? Would that be then like one big abuse, maybe strengthening each other or strengthening at least the effects of the abusive conduct? So if in the future a platform would only misuse data, would not be prohibited, or does it have to be taken together with another leveraging practice? And then staying with the data a little bit more, just one more question relating to the German Facebook case, which I think we have a parallel session on this afternoon, in which the Advocate General in his recent opinion said that competition authorities should not be able to apply or find a breach of the GDPR. And I was just wondering, do you think it would be better if they could do that, considering that competition law may be having a stronger enforcement, stronger effects in terms of also fining, so maybe, I don't know, have stronger teeth to enforce the GDPR as well, or would that give competition authorities too much power? So those were my questions and observations. Thank you very much for your presentation again.
Thanks a lot. Very thoughtful reflections. So let me see if there's questions from the floor before I hand it back to Thomas. Julian, I was already. Thanks.
If you have a question, like, you go first.
No, please go ahead.
Oh, I do not see.
Interesting. Makes me think again about these things. So I was wondering, how do you see the term leveraging? For me, these days I'm just thinking whether leveraging is just not a description of all kind of different abuses whenever you have like one market and you are thinking about effects in a different market. So kind of an overall category. But I had two more specific questions. You had this kind of clear separation, or that's what you said, and so I wanted to ask a bit more between looking at the conduct and then looking at the effect. And I was wondering, is that really what's going to happen? Because it seems so object and effect distinction focused that we have basically abolished in 101, where we have like this kind of economic gray zone where we look into the overall market structure and in the specific legal and economic context kind of thing, which somehow sits in the middle and connects the two. And then I was wondering about the economically rational test. I like it, but I'm wondering, and I think it goes back to a lot of discussions that we have always in competition law. What is economically rational in what time frame, right? And that's, I think, the main problem here. Also, if you think of even about predation is very economically rational in the long term, but in the short term, it's not. So what's the time frame that we should focus here on? Yeah, thanks.
Thanks. There was a question here as well. Yeah.
First of all, thank you both for your very insightful remarks on this interesting topic. I just want to pick up on something that Justine said, actually, on the topic of too many tests for too many abuses. In Servesio, Servesio touches on the notions of both indispensability and replicability, and whereby replicability, at least in my mind, relates to the infrastructure over the behavior. So where the behavior would be more of an indispensability issue. So I was wondering what you think the relationship is between those two concepts, if there's a distinction to be drawn, and does one entail the other, or are they even mutually exclusive? Because to my knowledge, there's not a lot of case law post Servesio. Okay, it's a case that was decided only a year ago, but I was wondering if this is something to keep an eye on, particularly given that replicability was discussed in the context of as efficient competitors.
Thanks. Back to you.
Okay, thank you very much for these great questions. I think I noted 7 questions, but you can follow up if I missed one. So first, on the test and pricing versus quality, and I think you're absolutely right. So in pricing, we have sort of a very mechanical test, and almost mathematical test that we can replicate across the board. It is true that when it comes to quality, you wouldn't have that, but I would argue that is not that's not a reason not to do the same kind of conceptual test and ask about economic rationality, ask about whether the behavior is predatory. Obviously, you need to sort of apply other modes of inquiry, but I think you can do it, and I think the case law shows that you can do it. If you look, yes, Baltic Rail, that was very clear. Another one, very clear one, is Deca Navigator, where it's very old, where the radio signal was jammed to obstruct the rivals. It was pure degradation. It was very obvious. But you see, like Microsoft is an example. Is an example where it was more sophisticated. They looked at industry reviews of these media players. They looked at internal documentation about the quality assessment, and they drew a conclusion. It's not as mathematically precise, but that's we're not mathematicians. We are lawyers, luckily, and so these things can be done, and in my mind they should be done. I think your point around thinking about the business strategy, I think that's actually a very important element, and what makes antitrust so fun, that you should think about how do these businesses compete? What is really their business rationale? That's, I think, sort of foundational to antitrust. And if you don't want to sort of commit mistakes, it seems to me that's something that needs to be factored in. Or, take in Google, we argued sort of, basically, what we were saying is like these designs that were at issue, and you see this a bit in the FTC conclusions, is like they were done for improving the search service. The rationale was this was rational. This improved the quality of the search service for users. And the evidence, also one piece of evidence, was there were sort of long-term studies, ablation studies, where you have a version of the search service without the design change and with the design change, and you look at how user traffic changes, and you saw that with the design more users came to search. So it's like the users like this and were issuing more queries to Google, and they were coming to Google. So you were doing this to improve search. That's our argument, that that's up for debate, but these kind of things. So you need to think about, how do I, in a particular context, in a search context, in a media player context, how do I apply it? But I think it can be done. But it's an important question. I mean, yes, there will be more debate around this. Good for the lawyers, that's for sure. Then I think on your question, like, different treatment. So there, from our perspective, we would very much argue different treatment is not enough. And I think there are two fundamental reasons why this is not enough. First is because it is normal competition to treat yourself differently to your rivals. So different treatment cannot be in itself sufficient to say you're deviating from competition on the merits. And in fact, you have like Bundesgerichtshof judgments, which very precisely say, like, look, this is not even discrimination, right? Because the rivals are not the same as your business. So different treatment cannot be enough. If you would use a different treatment standard, our fallback argument is you would have to establish at least discrimination, which is, again, a bit like irrational behavior. It's like arbitrary different treatment, right? Because you can very legitimately treat different things differently or based on objective reasons. So I think it certainly needs to have more than different treatment. And the other reason is that a big debate in Google, which I didn't touch on, is that we think this is actually a refusal to supply case disguised as different treatment. And you could describe every refusal to supply as different treatment, right? You are treating your own operations differently from the rivals who do not get the input. And so if you say different treatment is always an abuse, you have basically killed the Bruno standard, because you never need to show any more indispensability. You can recast it as different treatment. That's part of the big debate. I think you would be very happy then in the US. Obviously, they are totally the other way around. But I think our argument is that this doesn't fit with the Bruno case law. Now back to Amazon. I think that's actually so you question so indeed I think these are two abuses. They were actually originally, the commission brought two different cases, right? So one was about the data of the partners of Amazon that Amazon was allegedly misusing for its own downstream operations, right? It looked at what kind of products sell well of the rival retailers. And then it says, oh, this pillow sells very well. I'm going to offer also a pillow in my own downstream retail operation, and I'm going to compete against my partners. And I'm using the data of my partners to figure this out. And I think that's a nice example of predatory conduct, because if you are just the platform, that is not in the interest of the platform. You're degrading, if you want, the platform. You're hurting your own customers. So that's not, that doesn't make a lot of sense unless you want to have this advantage in the downstream market. But that was one case. And then there's the buy box case, which is more like the Google shopping case, where there was an allegation of favoring of Amazon's own retail operations in the buy box. But they were really separate cases. And so then leveraging as an abuse, and this is the same thing. So the court in the general court in shopping specifically says no. And you have an earlier case from the ECJ, I think it's Tetra Laval, where the court says specifically no, it can. So some leveraging is a generic term. Sometimes it denotes abuse, like a tie, like a margin squeeze. Those are leveraging cases that are abusive, but not everything that is leveraging is an abuse. And I think is fairly clearly now established. Also, the general court says that. So you still need to look at the behavior. What is it exactly? What is going on? Is there coercion? Is there predation? Something needs to be there that deviates from competition on the merits. And then on the question, like the mushing up of conduct and effect, and on the 101, I guess in 101, you always have the agreement. So that's your behavior if you want. And then it's indeed, the question is basically, is it restrictive effect, or is it by nature, by object restrictive? But you start with the agreement, and then, I need to be careful. I think the challenge with 102, or, what makes it very interesting from lawyers is it's very open-ended. It's unilateral conduct. So in principle, everything could be an abuse. And so then the question comes in, okay, where do we draw the lines? And it seems to me clear that the effects alone can't be it, right? It can't be. So you need something else. And I think analytically, it makes sense to distinguish between the two. I would agree that on pricing, it gets a bit mushed up, because you have the predation test, which sort of at the same time tells you, okay, this is anti-competitive, but also it's going to have restrictive effects. However, I think in pricing, you would still have the effects analysis stage with questions like, well, how much of the market is actually affected? Is this like a one-off thing, or the duration and so on? So there are still elements that you would do in the effects, in the narrow sense of the effects. And so again, distinguishing these two steps makes sense to me. And then
can I ask you to round off? I know there's still one question.
One last question. Yes. So then indispensability and replicability, I think they are very closely connected. I mean, that's my view, right? In the Bronner case law, you say like it is impossible to replicate, and it is indispensable for competing, right? And there's a risk of eliminating all competition without it. But I think both of these are very closely connected. So if you can't replicate it, then it's very likely that the competition will be eliminated if you don't have it. So there is at least a very close connection.
Okay, thanks a lot. I think it's clear that it's a very interesting discussion. We can keep discussing for a much longer time, but I think we have all deserved coffee. So thanks a lot to the speakers, to the discussants, and to the audience. And we'll meet here again for the keynote. I see that our keynote speaker, Martijn Snoep, has already arrived. So look forward to the next session, and thank you for now.